Apologies, ladies and gentlemen. At county this morning, the microphones had died, so it was voice only. So, but I'll have to remind myself that the mics here are actually working. Good evening, ladies and gentlemen. Welcome to the the December meeting of the Borough Council's Planning Committee. I'm Councillor David Jones. I represent the West Highcliffe Ward and I am the chairman. And although the officers and members here have their names in front of them, for clarity, because they're not always picked up by the cameras, I will ask everybody to introduce themselves, starting with Councillor Geary.
We just mentioned my name, so...
Well, this is true, but...
Councillor from North Highcliffe and Walkford.
Councillor Neil, Jumpers Ward.
David Hodges, Team Leader Development Management.
Linda King, Development Management Manager.
Daniel Lucas, I'm a Principal Planning Lawyer in Legal Services.
Councillor Colin Jameson from Burton.
Daniel Rina Farhi, Democratic Services Officer.
Councillor Peter Hall, Town Centre.
Councillor Denise Jones, Grange Ward.
And Councillor Janet Abbott from Grange Ward.
I'll just take a few moments to outline the procedure which we shall be following this evening. All members have each had comprehensive planning reports sent to them well in advance of this meeting. Each application will be presented by the case officer using the screen which members will see behind me and also is displayed on the screen in front of each member. After the case officer has made the presentation, I will ask those members of the public who have asked to speak to the committee to come to the opposite end of the table to me. The time limit is 3 minutes for each speaker, and in the interest of fairness, limits will be carefully timed and enforced. Speeches must not be derogatory and must relate to material planning considerations. When members of the public have spoken, I will ask members if they have any questions of fact to the officers relating to the application. After all questions have been asked, we will move into debate, and at the end of the discussion a vote will be taken, provided a proposal is made and seconded, and that the decision on that proposal, except in the very rare circumstances outlined in the Council's constitution, will be final. I must ask members of the public to assist us by making sure that their telephones are turned off or set to silent ring. If anybody needs the facilities, they're through the door there. And if should by any chance the fire alarm sound, there are no practices scheduled for this evening, so I'd ask you to leave the building through the double doors there out into the foyer and out, or through the double doors there and outside. I have to say that this meeting is being webcast by the council. It will be capable of repeated viewing, and by being in the room, you are deemed to have given your consent to be filmed should the camera pick you up. It is in my authority as chairman to halt filming if I feel it is dangerous to anyone's interests or the council's interests to do so. I think that's all the preliminaries. I thank you all for coming, and I'd especially thank Councillor Hall, who lost a fight with a radiator, I think, was it? Yes. And obviously is in, so I might not have any trouble from him tonight, I don't know. So we'll move into the agenda proper, and the first item, apologies.
Yes, Chairman, I got apologies from Councillor Davis and Councillor Hallam.
Thank you very much. Second item is declarations under the Code of Conduct. Councillor Hall?
Item 4B, Chairman. Item 4B, Chairman, is my property, so I shall leave the meeting. But I would like to take this opportunity of thanking the officers for getting it on tonight's agenda. Thank you very much.
The same item. It is obviously, I'm well acquainted with Councillor Hall, possibly to the extent that it might appear that I would not be able to approach the application with an open mind, and I shall therefore declare a possible prejudicial interest, though not a financial or pecuniary interest, and I shall leave the chair to my good colleague Councillor Jameson for that item. Councillor Mrs. Jones?
I'd like to declare an interest in Councillor Hall's application, in that we are friends of Councillor Hall and his wife, and therefore in the interest of transparency I will leave the room. On the item of St Anne's Cottage, I served for a very short time on the same committee as the applicant of St Anne's Cottage, but we no longer sit on that committee together, and I do not feel that I have any interest.
I will also declare for transparency on that item that I too was a member of the same ward committee or divisional committee of the Conservative Party as the applicant, but she no longer sits on that committee, so I mention that only for transparency. Councillor Abbott.
Just to say that I also sat on that same committee and was only on it very briefly with the applicant. I haven't got any personal interest.
Right, are there any further declarations? Councillor Geary?
Councillor, it's the standard usual rubric from myself, in the sense that you need to apply your own mind to the test in law, and that comes from a case of Porter and McGill, and that's whether or not you feel a fair-minded and reasonably informed observer would feel that you've come to a view which shows an apparent bias in the situation. That's the law. It's a matter for you whether or not you feel your connection with Councillor Hall is sufficient enough to be perceived as a friendship, which could then perhaps put in jeopardy your transparency and approach to your decision making. So it's a matter for you. I've advised you. It's up to you to decide whether or not you feel that connection is too close so that your judgment is impaired in any way.
For the same reason, Councillor Hall is also, I like to think I'm friendly with every councillor on the committee or on the council, but we have been past mayors together. We have socialised in that environment, but it hasn't caused any friction between him or I, and I'm on an opposite party to him anyway.
Again, Councillor Neal, just for the record, the same test applies. It's a matter for you. You know the law, you know the position. I've advised you. If you feel you want to recuse yourself, please do during that particular item. Thank you.
Right, that being out of the way, we now move on to the minutes. Do I see a proposal? Seconded. Is it your wish that I sign these minutes as a true and correct record of proceedings?
Agreed.
Agreed, thank you very much. So we now move on to item 4, which is the St Anne's Cottage, and Mr Hodges.
Thank you, Chairman. We refer you to the update sheet and in particular the receipt of a revised plan from the agent and a request from the applicant, the agent, that the application be deferred for the council to reconsult on those amended plans with a view to bringing the application back to the January Planning Committee once we have carried out a reconsultation with the relevant bodies, including the Highways Authority or Conservation Officer and interested parties such as neighbours and those who have already commented. We're in agreement with this request, Chairman, and we recommend that the application be deferred to allow for a reconsultation to take place on those amended plans.
Thank you very much, Mr. Hodges. I'm a little puzzled because I received a email or a copy of an email to you from the applicant at 4 o'clock this afternoon, in which the applicant has said that she wishes the application to be determined this evening, and in fact the applicant had previously advised me that she wished, win or lose, to have the application determined this evening. As I said, the fact that the applicant is here would seem to indicate that she wishes to proceed.
Thank you, Chairman. The process is that we take our instructions from an agent, where an agent is named on the application form. So the applicant is being professionally represented by an agent. The email that I received today, if I read it word for word for you, Chairman. Dear David, having discussed this with my client, she has agreed she wishes to have the application determined in accordance with the most recently plan submitted to you. The plan was received yesterday, 5th of December, and to have the application deferred to the January committee, which I understand is on the 17th. And then there's a description of the amendments that have been made to the plan, Chairman. So those are the instructions that, as officers, we've had from the applicant's agent.
On my understanding of matters in general, and taking as a precedent the officer's acceptance of a request from the applicant of the second of tonight's applications at a previous meeting that it be deferred, I have always understood that an applicant or that a principal has the right to take a decision, even if we're talking in a court action. I think we've all come across cases where a principal has suddenly changed his mind in the middle of a case, and despite the legal advice, I believe, and I'm open to correction from the legal advisor, that it is said that a person who represents himself in a legal proceeding has a fool for a client. But I would understand that in that case a principal must take responsibility. In the same way that the principal takes responsibility for an agent's action, it seems to me, and I will put this to the committee in the form of the officer's recommendation for refusal, or for deferral, for deferral. If that recommendation were to be refused, then I would be open for a further resolution in due course. But I believe, and again I'm open to legal advice on this, if the committee wished to hear the application, it would seem to me to be the committee's right, as the recommendation is that the officers have put forward a recommendation. We can deal with that recommendation in the same way as we can deal with any other recommendation. We can approve it or we can refuse it. So in this instance, we can act against the officer's recommendation and hear the application. Mr. Lucas, am I correct in that?
Essentially, Chair, through you, it seems there's what you said is rather straightforward and correct in terms of principal and agent instructions. However, what I can say is it seems the agent has taken instructions from her client, and the email you refer to comes from the applicant. However, there's an email to the local planning authority which is after the one you refer to, coming from the agent. Apologies, there seems to be a little confusion over the matter. I will be meeting my client at a committee meeting. It is her desire that the application be heard at committee, but she wishes for the most recent plans to be what is determined. As it needs to be put to committee for the item to be deferred, she is afraid that it will not be deferred by members and it will be decided in her absence. And in that regards, it seems the agent, who I believe is probably sat at the back, has taken instructions since the confusing email from the applicant, and those instructions are that the matter should be decided in accordance with the most recent plans, which were submitted yesterday, I'm led to believe. So therefore the agent has taken instructions, and those instructions have now changed, and it's unfortunate the applicant has perhaps confused the matter, but through her professional representative, it's now clear that she wishes the matter to be decided on the amended plans submitted late in the day yesterday. So your officer's recommendation is that it be deferred for consideration for those amended plans, and that the applicant has been fully advised and the agent has taken those instructions, and that is the applicant's wish today.
Vice Chairman.
Yeah. My question is, are the amended plans significantly different, and do we have sufficient information before us today to determine the application? Because if it's just a minor amendment, I would suggest that we crack on and get this done, because I do not like applications being deferred and deferred and deferred. It's not good for the applicant and it's not good for the council.
We were led to believe the amended plans were coming, and we asked on the 15th of November whether these amended plans were coming in or not. We received them yesterday. As far as we're concerned, they are of enough significance to warrant a reconsultation, and that is why we are recommending the application be deferred to allow a consultation on the amended plans, as this is a property that affects a listed building and is in a conservation area. It would be normal due process to seek reconsultation on those amended plans, and that is the agent's understanding as well.
I am totally confused. I am going to take the step of adjourning the meeting formally for 10 minutes. So could the recording please be turned off? And I would perhaps the Vice Chairman, myself, the officer, the applicant and the agent could get together briefly and we can maybe nail this down. So I'm going to adjourn this now it's now 6:20. I will adjourn the meeting until, let's say past, and if we're ready to resume before then, we will see. But I am, as I said, I would like to hear the applicant's views, and I don't think it's appropriate to hear them in this instance in the formal committee. So this meeting is adjourned for 10 minutes. So perhaps the applicant, we could... Apologies?
No, it's being adjourned, Nick.
Sorry, Councillor Geary.
Yes.
I haven't adjourned yet. Do you want to? Is there anything you wish to say? Yes.
I'll comment. As heritage champion, I haven't seen the new plans. I don't know what's in the new plans, and I would actually verge on to caution, and I would like to see a deferment as myself.
Well, I think that, yes, that is fair enough, but I do wish to know, as I said, I hear on the one hand the applicant doesn't wish to defer, then the applicant's agent says we do wish to defer. I understand what the Vice Chairman has said, and I'm in agreement with this. With this, justice deferred is justice deferred is justice denied, and while I accept that, and there are two, we have a former heritage champion and the present heritage champion with us, and I appreciate that. But at this moment in time, I think that it would be beneficial if we could have an adjournment and we can find out where exactly we are. So, meeting is adjourned for 10 minutes. and Councillor Mrs Jones and I will leave and we'll decide the next item. So, and I will be back in a second or whenever.
Give me a chance to get it.
We have a result of what?
We don't know yet.
So I'm going to stay out
Sorry,
and go home.
sorry.
I'll leave it with Councillor Jameson.
Surely that's our decision.
What? So whilst the applicant and the applicant's agent are having a little discussion, it was felt in order to expedite matters that we carry on with the next application and then we would get guidance very shortly. So agenda item 4B, amendment to application 8180951 HOU. Who's leading on this, please?
Chairman, that'll be myself. Thank you, Chairman. This is a non-material amendment submission in relation to the site at 24 St Margaret's Avenue in Christchurch. Non-material amendment procedure is one which allows you to make non-material changes. I was going to say minor, which would be the wrong word to use. Non-material changes to an existing planning permission as a streamlined procedure to avoid a full planning application. This is the site of the property here. It's a shallow bungalow. The works approved are in relation to this hipped roof here, which has approval for an extension out to form a gable end with dormers to the east and west elevations. This is the red line site around here on the corner plot, opposite Sophers Lane, Ropers Lane, sorry, Sophers Lane. So this is the existing site plan of the property on the site. So these are the current elevations. This is the hipped roof here on the right hand side, which gets extended. And at the moment you can see there's a dormer on the west elevation facing out. These are the currently proposed plans. So we form a gable end on the end here, and then dormer windows on this east elevation and west elevation are proposed. Under the planning consent, this window in the south elevation and this window in the east elevation are required to be obscure glazed. This is your proposed floor plan showing your openings within the window, within the room. And this is just a comparison of the scheme that's approved. So in effect, the dormers are slightly smaller and the glazing area is reduced. Chairman, where we're dealing with a non-material amendment, the test is whether the changes are material or not, bearing in mind the consent that already exists. And we're completely satisfied that this falls well squarely within the scope of a non-material amendment, and we're content to recommend it to you. And just to confirm that as a non-material amendment, all existing conditions carry on from the original approval, Chairman.
Thank you. It's my understanding that the reason this is before us this evening is because it's an application put forward by a member. And I also understand that had this application come through from a member of the public, it would have gone through under delegated powers. I see no reason for this application to be refused. I'm looking for a proposer. Councillor Neal. I'm looking for a seconder. Proposed and seconded. Is there any debate? I beg your pardon, I should have asked, are there any questions? No questions, no debate. We go to the vote and I will vote. All those in favour, please show. Thank you, that is unanimous. Thank you very much.
I thank members for their thorough deliberation over that point.
I have explained what's been happening.
Yeah. The applicant said as I was coming through that she was inclined to... So the plans as before us.
The ones before us, the ones that we recommended for refusal.
Okay. Right, ladies and gentlemen, thank you for your patience. The applicant has asked that the matter be determined tonight. So we must now, first of all, can I ask, I think the correct procedure, the recommendation is for deferral. So I think, do we wish to, Mrs. King?
Through you, Chairman, we can now remove that recommendation from the update sheet because the recommendation was made in light of the amended plans received. Those amended plans have now been rescinded by the applicant, and the request is to determine the application on the plans originally submitted. So on that basis, I don't think we need to take the matter of the deferral any further, and we're back to the substantive application.
So we now move straight into making into, as we would, dealing with the two applications which are basically the same thing, the householder application 818-2131 and the listed building consent 818-2132. So I'll ask Mrs. King to introduce the application.
Chairman, I'll present the item.
Apologies, Mr. Hodges.
No, that's absolutely fine. Yes, so Chairman, this is an application for the removal of the front boundary wall and the partial rebuilding of that front boundary wall to create a parking space in front of this great listed building. The site is in here, sited on the main B3347 in Winkton and also within the village's conservation area. This shows you the application in its context and the surrounding roads within the village. This is indicating the works to be taken, in particular the proposed, this says existing drop curb, and then the removal of the walls in terms of how this site is currently existing. And then this indicates the proposals to rebuild partially the wall that's been removed and extend the drop curb. So this is how the property appears currently, and for the records, the current appearance of the site is unlawful due to the removal of the boundary wall in front of the premises. And this indicates on the right hand side the existing wall coming out on the north side, which is on here. This is a proposal for before members to partially rebuild this wall here and form within this area here a parking space in front of the dwelling. So this is a view of the site as it is currently, with the walling removed, which was formerly in this area here, and we've got a photo which gives you a view of the wall as it previously appeared. These are photographs submitted by the applicant as part of their design and access statement, showing partially the wall, the applicant's vehicle parked there, and then how the site is currently arranged with the applicant's vehicle here and the walls removed on either side. Chairman, one of the reasons for the principal reason for the deferral of the application back in October is in relation to information that we received on, I believe, on the day of that particular committee, with regards to whether the wall was in existence prior to the listing of the property in the mid-70s or not. You'll see in the report that we have looked into that issue and considered this information, given due regard to the submission. And you'll see from the report our view that this doesn't make the case that the applicant was trying to make, and in fact the photographs appear to indicate for us very clearly that there's a wall there at that point. And this is, if you look top right, this is how the wall was prior to its demolition. These are just some views to help you with the issues of the highway safety and the depth and gap that you would have in order to park a vehicle on the frontage. In particular, this is the standard parking space from the Highways Authority's own guidance. Unfortunately, we don't have the Highways Authority here, but this is taken from the adopted guidance within the adopted planning parking guidelines, and particularly where it should be noted that where a 5 metre by 2.8 metre standard parking space, in effect that's a Tesco's car parking space where you can pull in, but where you are looking to do in effect what would be a lay-by style arrangement, you would need a longer length to allow you to pull in and pull out, hence the reference to 6 metres there. This is to indicate how are concerned that it would not be possible to park a vehicle clear of the highway, and therefore there is, following from that, a significant highway danger as set out by the Highways Authority should the works go ahead. To emphasise the point, as I say, the above view is taken from the applicant's own submission, and the vehicle currently overhangs the highway, and clearly as officers we have a significant concern for pedestrians and the possibility that there'll be insufficient room for someone with a buggy, pushchair to pass, and the prospect that they may be forced into the public highway as a result. And also, as part of the reasons, you'll see that we have concerns over the impact on both the conservation area and the setting of the Grade 2 listed building, both in terms of the removal of the boundary wall. The boundaries are a positive feature, defending the public space from the private space, and form part of the wider setting of the conservation area. This particular issue is specifically picked up on in the adopted conservation area appraisal for Winton, and we make no apologies for putting that quote out in full. There's also been a limited loss of boundary walls to make spaces for parking. Where this has happened, it has compromised the immediate setting of buildings that make a positive contribution towards the character and appearance of the conservation area. As a Grade 2 listed building, the application site clearly makes a positive contribution towards the character and appearance of the conservation area, and the proposal before you, from our point of view, sits very squarely within that concern in your adopted guidance. Just to show you some detail of the wall, but I think particularly in relation to the wider setting and conservation area arguments, these are the properties further north along. These properties are also listed. Their boundary walls are identified in the conservation area appraisal as important boundary walls as well, and you'll notice the similarities in form, size, height, materials to the wall above. And again, whilst there's evidence that the means of enclosure has changed over time, which is not unusual, so I said a clear division part of that character of the terraces, that separation, defending that space between the public and the private. sorry, I've been through that particular slide. So this is just some detailed slides from the street scene as it is currently with the main Salisbury Road, the site here, and again, you can see the vehicle overhanging the public footway at that point. And just some views back where you can see the other boundary walls also in context with the proposed site. And just some close-ups to see our concern about the lack of space to park a vehicle off the site, and also to appreciate how that affects your appreciation of the listed building when you view, or rather you can't view, some of the characteristic features. So, for example, these decorative porches are mentioned in the listing description and also in the conservation area appraisal. So these are an important feature which are in effect obscured by the proposed parking space. Chairman, just to highlight another issue that we've had with a similar site elsewhere, further down on the Salisbury Road, actually in Burton itself. Now, from the OS map, this part of the road is a B-class road. So it's a B-class road on the application side. Here, coming through the east side of Burton, it's a C-class road. And this particular site at 56 Salisbury Road, an application 180622, you see that the proposed parking spot was indicated there. And we draw your attention to the highways comment on this site as well. This site is one where someone could pull clear as the public highway. And the comments of the Highways Authority was the applicant needs to provide on-site turning so the vehicle may leave the site in a forward gear. If the applicant does not have space within the site in order to turn the vehicle, they'll need to install a turntable. If the applicant does not provide this, then they'll have to recommend refusal. There's a junction in close proximity to the site, and there's also a shared footway cycleway running along the front of the site. We therefore do not want vehicles reversing out at this location, as it would be likely to create additional dangers and hazards contrary to the interests of highway safety. And the application was refused on that basis. Chairman, you'll see we set out very clearly in the report our concerns about the proposals and potential impacts of it. We believe that they're clear and straightforward. We do not feel this is to be a finely unbalanced recommendation. We're very clear about the harm that will accrue as a result of the proposals in terms of the highway safety, in terms of the impacts of setting a listed building in the conservation area. And just to emphasise the further comments attached to your update sheet from the Conservation Officer and their particular additional concerns, which at the briefing you requested, Chairman, for them to set out. I don't know if after the presentation you wanted to give members a minute or two to just read through that rather than myself read through it. And my final update, Chairman, is in relation to a letter of objection that we received since the report was submitted. I set that out in full because we haven't actually had previously a letter of objection to the scheme. Ordinarily, where a late letter is received and it doesn't raise issues not addressed in the report, we will advise you as such. And in this particular instance, we hadn't set out a neighbour objection before in the report, hence that's why that's set out in full there. So tying those matters up, Chairman, we have a significant concern about public safety from the use of the access. We have a significant concern about the character and setting of the listed building and the conservation area from the removal of the walls and the potential precedent that may set for other proposals further up the street. And we also have a concern due to the proximity of the adjoining property here and the tortuous nature of being able to get in and out of that space, that the noise and disturbance that would accrue directly outside this property would have a significant and detrimental impact on that property's living conditions. And we recommend refusal for the reasons set out in the report, Chairman.
Going on, so I'll repeat that just for the record. Welcome to the committee. You will have a few moments to introduce yourself. The green light will come on. When the yellow light comes on, you have 30 seconds. When the red light comes on, you must stop. Thank you.
Good evening, Chair and members. I just want to firstly... Is that better? I'll just address a couple of points first. Along with the photograph that we provided prior to the committee last month, we've also provided statements from various individuals, including the property, the neighbour next door, her daughters. These were provided as statements. They can be, or were going to be provided as signed statements and affidavits, but they contradict what the officer has said about the wall. And the photograph that's been highlighted that's behind the bin on the bus stop post is the wall in front of Kimbolton Cottage, rather than in front of St Anne's Cottage. So we do not believe that the wall was in place when the building was first listed, and it's of no historic interest. We don't believe that a listed building consent is now required, but in the interest of expediency, we've kept the current application in. Just another thing to note is that we're not trying to justify the development on the basis that the wall had to come down because it was unsafe, but simply explaining why the development was applied for retrospectively. This is the second application to be made. The previous application sought complete removal of the front element of the wall, save for a section measuring 1.6 metres wide on the left-hand side of the property. This was refused for the single reason that it was harmful to the setting of the listed building and conservation officer, and hinged on the conservation officer's opinion that the wall enhanced the character of the frontage and street scene. Because the conservation officer's opinion seemed so fundamental to having the application supported, we've resubmitted with a wider 1.8 metre wall on both sides to retain what the council felt was an important boundary. Unfortunately, this change has been at the expense of the support of the highways officer, who now feels the gap to manoeuvre the car into place is too small. She has manoeuvred her car without problem or incident since the wall's removal in December 2017. The highways officer has naturally taken a cautious approach, but in reality the arrangement is perfectly adequate. The safety aspect of this arrangement is to be weighed against the alternative, which is a return to on-street car parking, which is in itself far more hazardous, as Lindy will attest. This application enjoys a high level of local backing, with at least 21 letters of support, and it's only just received one objection many weeks after the consultation period expired. The report refers to a problem with the neighbour's amenity by way of disturbance. This was not raised as an issue with the previous application, and nor has the neighbour complained to Lindy or the council since she's been parking this way, and they have not objected to the application. It's also never been an issue with other similar applications the council considers. We are appealing to members' common sense and pragmatism in approving this application. The wall was not a historic addition to the building, and it does not harm the significance of the building. There is no heritage harm. We've tried to reach a compromise, and hopefully that you can see this as a much safer arrangement than previous.
Thank you very much. Ms. Stewart-Clark. Again, you'll have a few seconds to introduce yourself, and then the green light will come on.
Good evening, Chair and members. My name is Lindy Stewart-Clark, and I live at St Anne's Cottage, Winkton. In the statements provided and the photograph of 1979, there is no evidence of a wall across St Anne's Cottage. The wall you see is across Kimbolton Cottage. Evidence from 3 statements say that a wall was not present until one was built around 1985. Mrs. Godwin, my immediate neighbour, applied for a dropped curb and parking in 1977 after the listing of the buildings. It was approved. My car, parked at an angle, does not overhang onto the pavement. In the conservation report and in the conservation officer's opinion, he states that my vehicle parked across a pedestrian path and near the centre reservation of the main B3347 is adequate facility for parking. My question to this is, would a disabled person using the same pedestrian path agree? And would the Association for Disabled Rights agree? There has been around 50 or up to about 50 letters of support that I thought. I don't know if actually some of them got sent through, but I thought there was about that amount. Car crashes on the Salisbury Road, B3347. Car crashes on this road becoming prolific, most incidents unreported. Winkton Association has asked residents to be forthcoming in advertising or advising them about all crashes so they can be logged. Reference to this is in the Winkton news sheet. Accident 30th of August 2018 at 7:30 a.m. 4x4 crashed into a parked vehicle between St Anne's Cottage and Winkton Lodge Cottage, dragging the hit parked vehicle along the pedestrian path into an off-road parked vehicle at Winkton Lodge Cottage. The crash coming to rest with the 4x4 on top of the vehicle balanced on two wheels, photographs included. 8th July 2014, the van that drove off the B3347 at St Anne's Cottage onto the pedestrian path and hit the off-road parked vehicle at Winkton Lodge Cottage. Mrs Godwin escaping near death as her car was catapulted across the main road into oncoming fast-moving traffic. When this crash came to rest, dogs from the van leapt out onto the main road, giving to a chaotic crash scene. Safety along the B3347 Winkton is now crucial. The road roaring through the core of our village is untamed. The resident at St Anne's Cottage only parking is the B3347. All residents in Winkton have access to off-road parking within their property boundaries or immediate lay-by parking outside their homes. St Anne's Cottage has none. Less vehicles parked on the main road, Salisbury Road, I believe. Thank you.
Are there any questions back to the officers on the information we've heard? That's all.
Thank you very much, Mr. Chairman. Well, I am concerned and confused. It's very confusing tonight, but Mr. Hodges with his car parking size. I've been on the county planning for many years and this one, and a standard car parking space, in my opinion, was always 2.4 by 4.8, and you showed us it was 3 by 5. We've just recently done extra car parking in the town centre, and the size was 2.4 by 4.8. So could you please clarify what it really is, please?
Chairman, yes. The diagram and the information you've got there is from the adopted residential car parking design guidance, and the reason for the car space growing is simply because cars are larger these days. I believe if Mr. Savage from the Highways Authority is here, he would be able to tell you that a current VW Golf is 1.5 foot longer than its 1970s equivalent. So that's the reason for extending the car parking space to accommodate larger cars, Chairman.
Thank you for that answer. If I could have another question, Mr. Chairman. On 8.4, and it does concern me, there's a heritage statement stating that the wall was mid-20th century. Have we any evidence when this wall was built, please?
Chairman, I think the short answer to that is inconclusive. The information that has been submitted to you, we believe, doesn't demonstrate that the wall wasn't there when the property was listed. So, from our point of view, we don't have conclusive evidence that the wall post-dates the listing of the property in the mid-70s.
Can I ask the corollary of that? Is there evidence, hard evidence, that the wall predates the listing?
As Mr. Hodges has said, there's no evidence in either direction that's conclusive. When a property is listed, the listing that accompanies the application or the building usually just relates to the building itself. So there is no details on the listing of this property as to whether there was a wall there or not. We have no evidence that we can that is conclusive to say it wasn't there, And in discussions in respect of the enforcement notices that were on this site previously, it was discussed that that wall was there since about the 1930s.
Councillor Hall.
Sorry, Mr. Chair, I did have another question before you can I carry on? The other one is that for many years I managed to use PPG 15 conservation area, and it states very clearly, because throughout this report you're saying does it enhance, etc., etc. I was understood from that document that providing that it wasn't detrimental, it didn't have to enhance. There's no legal reason to enhance, but providing it stayed the same as stayed balanced, that was fine. Is that still the case, please?
And Chairman, the statutory test is unchanged, and the statutory requirement is to preserve or enhance the conservation area, preserve or enhance. But also what the council needs to do is apply the guidance in the National Planning Policy Framework. And what that says is where you may have some harm to a heritage asset, you need to balance that against the public benefits of the proposal. So what you would need to do, as we set out in the report, is to say if there's a harm that arises from removing the front boundary wall, is that harm mitigated by some other public benefit, like providing off-road parking, for example? But in this instance, what the conclusion is in the report is because the Highways Authority are advising you that that parking space is unsafe, in effect, the public benefits fall away. So what you end up with is both a harm to the heritage asset, but also a harm to public safety from the highway, Chairman.
Thank you very much for that answer. Thank you, Mr. Chair.
Yeah, I was just looking through the papers then on the existing drop crossing in 18, in 8th of the 18, it was refused for an extension to the existing road crossing. But according to the photographs, there were no drop curbs on the earlier photographs. So I can't see when the original application was made to put in for a drop curb. Do we have a date on that?
I think the question is, do we know when the drop curb was made?
No, Chairman.
But I think it's worth noting that it's not actually a full vehicular drop curb, it's a pedestrian drop curb.
Thank you, Chairman. Just going back to the point that Councillor Hall made earlier on the dimensions of the car parking, and at County they're using the smaller dimensions of 4 by 2.4, and we're using the larger dimensions of 5 by 2.8, which could be reduced to 2.4 if a 0.4 metre clearance is available. What is the dimension that you have shown in the plan where you have superimposed the one on the other? Is it the larger one or the smaller one?
Apologies, Chairman, does that answer the question in terms of the distance between the proposed walls being less than 4.8? So,
the question is, you showed a picture which superimposed your parking dimensions on top of there, but you didn't put the dimensions on there. Now, clearly, you're not going to park a car like that, and you're not going to park it in quadrature to that either. So, what are the dimensions of that red line?
That's the standard parking space of 5 by 2.8.
5 by 2.8. Thank you. Not 4 by 2.4, which I think is significant.
Thank you very much. Are there any further questions? Councillor Mrs. Jones.
Thank you, Mr. Chairman. Could I ask the officers, am I not correct that each of those cottages along there has a dropped curb in front of it?
Chairman, I can't answer if every single cottage does. I don't believe that helps you in this particular instance, because the broader point is that there aren't any accesses to provide vehicle parking in the frontages of those other cottages.
Could I follow up, Mr. Chairman? You said that the dropped curb here was because it was a crossing point. Well, that means that all these cottages have also got crossing points, which seems rather strange. But could I ask, the Winton Lodge cottage on the right, is that also part of the conservation area?
Chairman, yes, that's in the conservation area, yes.
So when we're looking at the question of does this detract, would you not say that the high hedge which hides half the cottage to the right also detracts because you cannot see? There is a great big thick hedge which goes round all the neighbouring cottage. So if we're saying something is going to block this view, is that not true of the hedge?
There is a hedge there, but that's not before what members. That's not one of the issues that members are taking into account. You have an objection from your from the Highway Authority that the use of the site in the manner proposed would relate into highway danger, or would interfere with the free flow of traffic on this part of the B-class road.
Thank you. But I'm actually referring to this idea of the visual impact. We've been talking about, it will impact on the view, not just the road safety, the view of the cottages. And my question is not that hedge also impacting on the view?
The hedge is not development, so it's not something of which this council has control. The applicant or the neighbouring property can put a hedge there and can be as high as they like, providing it doesn't then interfere with the highway. If it overhangs the highway to a greater extent, the Highway Authority have the ability to ask the applicant or the owner to cut it back or to do the work themselves if it isn't done. But we're talking about the visual impact of the removal of that wall and the car parked in it. The photograph before you shows the change to the setting of that property, and I think we've shown earlier photographs which show the setting of this part of the conservation area. You also have your conservation area appraisal, which makes comment on the importance of the retention of the means of enclosure along this part of the conservation area, and the fact that those features should not be lost. They would have an impact on the character of the conservation area.
Thank you, Jim. Will you just clarify the position of the pier on the left-hand side of the photograph? Is it the form part of the curtilage of the man's cottage or the other?
I would have to ask the officers for advice on this. I think that's what they call a very fine question.
Chairman, I think you're straying into issues of land ownership. There, it would appear to lie within the curtilage of the application site.
Right. I think it's inconclusive. I think to do that you need the land registry plan.
Why I ask the question is that if that pier is on the property of the neighbour, then part of the wall has been removed, then part of that neighbour's curtilage has not been added.
Chair, through you, that's simply not relevant in the sense of the application before you. The applicant would have submitted a certificate to say that they've notified that they are the owner of the actual red line site for the actual application, and that certificate would have accompanied the application. As to whether or not it's in the curtilage or not is a matter of civil law, and trespass, and it's not a matter for the local planning authority.
Are there any further questions? In which case I would like to ask one or two questions, if I may. At the chairman's briefing, the question of the highways and the opinion of the Highways Authority was raised, and I volunteered to seek clarification from the county highways officers responsible. As members will know, I'm also chairman of the county's regulatory committee, so we had a meeting this morning, and I took the opportunity to speak to the county officers and to raise the question of their concerns over this, because obviously on one application they decided they had no objection, and there is an objection on this application.
Chair, I must caution you at this stage, this isn't before the officers, and to all intents and purposes you're straying into matters now which are outside the knowledge of the local planning authority and the officers who are tasked to consider the application. So your conversations that you had following the chairman's briefing with the highway authority outside the usual consultation process is not before the officers, and they haven't had or been privy to those conversations. I urge you to desist, because you'll be straying into a remit of materials that haven't been placed before your learned officers for your consideration today. Furthermore, it could, to all intents and purposes, show a strong inclination with respect towards bias and predetermination. Thank you, Chair.
I thank the officer for that. I will be very careful in how I express this next point. And I will ask the officer very simply, are emails exchanged between the borough officers and the county officers matters of public record?
Chair, I can answer that question if it helps. All correspondence is subject to the Freedom of Information Act 2000 and the Environmental Information Regulations 2004. Any member of the public, be it professional or indeed a non-professional member of the public, can make those requests under the Freedom of Information Act 2000 and the Environmental Information Regulations 2004. Such regimes exist to allow any member of the public from within the borough or outside the borough to make requests for such information.
Am I therefore within my rights in asking the officer about email communication he may have had in November with Mr. Savage?
Chair, before the officer answers that question, I'd like to know where it's going and whether or not it's material to the committee's decision.
I believe it would be in the committee's interest to be advised of the contents of an email from Mr. Savage on the 26th of November to Mr. Hodges, copy to Claire Marshall, relating to this point, which gives details of the view of the concerns as to the traffic dangers, and to the, I'm quite happy to show the officer this email, as I think I have.
Thank you, Chair. Yes, so obviously reading two email correspondences here, I think the planning officers are better placed than I to obviously talk about emails received to and from the planning department and planning officers. So I defer to my learned colleagues in the planning department.
As we've previously set out in the agenda report or the agenda presentation this evening, we had an application elsewhere recently in Burton where we had a recommendation for refusal on highway grounds on highway safety for a lesser class road, and where the applicant could actually manoeuvre the vehicle wholly off the public highway. We therefore wanted to know why there was a discrepancy between what the so I have to find the right thing because it keeps pinging away from me. Why there was a discrepancy between the officer's recommendation in respect of this application site, which is on a B-class road, which is a higher order road with a greater traffic road, and on the C-class road. So we asked for clarification because that's what we are required to do when we get a difference of opinion from our consultees. It's not unusual to go back to consultees and say to them, well, this is slightly different than the comment you made on the very similar site elsewhere. Can we just get your clarification as to what you wish us to deal with? So it's not an unusual situation. What the highway authority or the officer then has said to us. Do you want to read the whole thing out, Chairman?
Obviously you can't read the map out, but
no, I can't.
I would think from the from where it says in highway safety terms, if you wouldn't mind.
Okay.
And the second part is in the report.
Yes.
In the italicised part.
Yeah. In highway safety terms, there's a fallback position. If the applicant removes the front boundary wall or the elements she is seeking to rebuild as part of the current application, then the vehicle can safely enter the site and park within the front curtilage. The previous application, 18060, was, as you know, acceptable to the County Highway Authority with the stance taken that we have a benefit to the free flow of traffic in addition to general safety along Salisbury Road if the vehicle would park clear of the public highway. This assessment still stands. And then there's a map showing a collision history in this section of Salisbury Road over the past 5 years. This confirms that there is no cluster point in the locality of the site, nor is it a recognised accident black spot. Unfortunately, neither Claire or myself will be able to attend your next planning committee, but I would hope the paragraph above was a simple explanation of our position. I would also add that it may well be beneficial if we weren't there, as if pressed, we would have to confirm that removing the wall would solve the problem, as far as we're concerned. With regard to amending our formal recommendation, I'm prepared to issue you with the following replacement. The submitted drawing, proposed plans and elevations proposes a new wall and pillar 1.8 metres wide on either side of a 4.1 metre wide access into the front curtilage of the property. These dimensions, coupled with the depth of the proposed parking area, mean that a vehicle cannot freely enter and leave the property, with the likelihood of a vehicle parked within the site overhanging the adjacent footway. Hence, the County Highway Authority recommends that permission be refused for the following reason. And that's the reason as set out in the report.
Thank you very much. Thank you. Are there any further questions? So no further questions. Councillor Jameson, you're the ward councillor.
Wow. Thank you, Chairman, for giving me the opportunity to speak on this matter. And I'm going to start off with a couple of peripheral points, both of which have been spoken about this evening. And if I used incorrect terminology, it's not because I'm doing anything Machiavellian, it's just because I may not know the correct terminology to use, so I beg your indulgence. And it's to do with disabled buggies. Now, I was involved a little bit further down the road from this application, where a vehicle was parked on the pavement and a disabled buggy was coming along the pavement, it was a cycleway, and could not get past. And I happened to be there in my car, and I pulled up and I called the police. And Brenda, remember Brenda? Yeah. She came along, got a police car to take the passenger home because they live in the village. And I had to then manoeuvre the disabled vehicle off the pavement onto the highway so I could get it back to where the person lived and then make my way on the journey that I was doing. So vehicles parked on the pavement cause a huge problem in our village, where the pavement is narrow and the vehicle speeds are quite high. I would like to now talk about the issue of the B-class road and the C-class road, and members who are familiar with the village will know that the C-class road in question is near the Oak Inn, where you've got a huge volume of traffic. There is a bespoke cycleway because it is a safe route to school, and it is in a chicane. So the differences between the two could not be more marked, and it is totally irrelevant in the application that is before members this evening. And that brings me to the point of the debate this evening, and whether the application should be approved, granted or refused. And I take a counter view to the officers. I say it is finely balanced. It's a finely balanced judgment. And the reason why I think it is a finely balanced judgment is because whether it preserves or enhances the local environment is unclear, and the officers have said that it is unclear. So the effect of the wall or not of the wall is neutral. And it may have been different if there was a consistent pattern of walls all down the road, but some of them are railings, some of them are hedges, and in fact, if you look at the property to the right of St Anne's Cottage, there is a significant addition to the building in front of the building line. There is a huge hedge that is surrounding it, and clearly, had there been a wall there, we don't know, but it's not there now. So there is a precedent that shows some buildings have walls, some buildings don't have walls, some buildings have railings, and some buildings have hedges. And I think that is why it is not clear whether it enhances or preserves the heritage aspect of this application. So I then come to the Dorset County Council Highways, who have cast an opinion, because the Highways Agency or the Highways Department at the upper tier authority does not have a right of veto of telling us in a borough council whether we can turn down an application on highway grounds. They can only give an opinion. And their opinion is that it is better to have vehicles parked on the road, which vehicles don't do. They park half on the road and half on the pavement, because to have the bigger vehicles, as was alluded to this evening, vehicles are bigger today, taking up half the highway, make the passage of the traffic more complicated and not less complicated. Now I've looked closely at this for months, and every time I drive past, I look at what's going on, what's happening. There are always cars parked there, and there are always challenges of traffic trying to get past. And whilst it is a 30 zone, people drive more quickly in order to get through. You know, it's just what it is. But it is a straight road. And in my view, if there was anybody reversing out of that frontage, they would not have any difficulty in seeing what was coming along the road in either direction. I think it is just not an issue. So the safe access to the highway, I believe, is greater with having vehicles parked off the road than it is with vehicles parked on the road, or half on the road and half on the pavement, denying access to the disabled buggy type scenario that I was talking about earlier on. And the pavements are narrow, 3 foot, I think, maybe less than 3 foot. So if you imagine pushing a buggy down there, it is difficult. If you imagine pushing a buggy down there past a car which is parked on there, then it's impossible. You have to go onto the road. And there is evidence, there is clear evidence in the plans that have been shown of where vehicles do park half on the road and half on the pavement, because you can see where the pavement has been eroded. So, Chairman, on balance, I have listened carefully to the presentations. I've listened to the presentation from the applicant. I've listened to the officers' presentations, and I've listened to the questions that have been put before the officers this evening. And I do not believe that stacks up. It is my view that this application should be approved, and I am certain that if it went to appeal, that it would be approved on appeal. So I am going to propose that this application be approved. Thank you.
Is that seconded? That is. Thank you. That's seconded.
Happy to second, Mr.
Thank you. Do I see another speaker? Councillor Neal.
As people may know or may not know, that I sit on the West Christchurch, chairman of the PAC team, or now called NPT, and in our West Christchurch wards, our roads are also very narrow, but it is the police's opinion that parked vehicles on the road slow the traffic down. So there's a contrary argument to what you're saying in your summing up. So I'm not too sure that we're actually really there. And the property next door to the right has got very high bushes, as been explained tonight. And I think there is a highway safety issue about exiting onto the pathway. So I'm not sure. I don't feel I can support your proposal.
Okay, so further speech. Councillor Mrs. Jones and Councillor Arthur.
In the years before Councillor Neal, I was the first heritage champion of Christchurch when English Heritage established these, and I went to numerous conferences on heritage. I was very involved, and as a historian was already interested in this question of preserving heritage. But I think in all things there is a fine balance. have to look at things in the full. And I cannot see how a car that is parking there for a period of time is going to ruin a heritage aspect which can be seen, unlike some of those nearby which can't, but are still regarded as part of the heritage setup. I too have used, as most members will know, have used mobility scooters for a large number of years. And if I might say so, the cars that are parked partly on the pavement and on the road are a hazard beyond belief. Looking locally, through a long Sandpit, it is taking your life in your hands and you can't actually move along there. You have to go into the road. So if it's a choice of one or the other, I would support moving the car off. I don't think in this case it's going to do irreparable damage to the conservation area, and I would support the proposal.
Yeah, I believe somewhere along the line there was the history of the widening of the road where they took some of the frontages, took some hedges away. And the very fact they took hedges away at that time, hedges, not walls, whether it's relevant, I don't know, but it just popped into my head. Yeah, the question of traffic parked on the road slowing traffic, it rather depends where upon that road the traffic is going to be slowed. If it's on a dangerous corner, for instance, I drive often up and down this road, so I've experienced a lot of that myself. I did stop and walked along, had a look at that hedge, at where the wall and the picture, when I saw the picture, and I'm quite satisfied that it is as the applicant says, that the wall was built later. When you see the photograph alongside the actual place where you're standing there, you can see it much better than just looking at the photograph. Also, I do feel that from the pictures, when you're talking about street view and the look of the place, it looks much better when the car's on the frontage than in the road, because you can actually see more of the house when the car is parked up close to the house. There's more in view. So with those things in mind and things that previous councillors have said, I would support the applicant.
Yes, Chair, thank you for the opportunity, and through you. There is an issue about whether or not the wall forms part of the original listing, and Councillor Abbott, you made reference to perhaps it not being the case, and it being built after the listing. I think it's only right and fair that all of the facts are before you, councillors. You've probably seen me ferreting away, and I've looked at the actual application and the applicant's own heritage statement prepared by Savills and prepared by Dr. Nikki Cook, and it was verified accordingly and submitted with the application. The applicant's own heritage statement, interestingly at page 5, paragraph 2.3.6. However, the distinctive red brick wall was in situ when St Anne's Cottage was listed in 1976, and as such forms part of the listing, albeit it could be argued that it is out of character with the rest of the terrace. So the heritage statement prepared for the application concedes the point as to whether or not the brick wall was there at the time of the listing. And that's the applicant's own heritage statement. So I think it's only right that that fact is put before you as well.
I wonder if it is possible to inquire a little further, because the point that has been made is that since the application early application was made and the objection was raised, the construction of the wall, the date of construction, has come into question. And I wonder whether, again, this is one of the things that you have to say. If Savills had said, and it states that we had evidence to support their comment, then of course that would have to be taken as fact, and then we would have to move into the question as to whether or not the wall was of sufficient character as we feel to justify preserving. As I have said a number of times, as a historian, the fact that something is old does not mean that something is good. A fact that I feel as I get older is, and creakier is more and more apparent. So I think that's a fair point. Is there any evidence, concrete evidence? We have evidence that has been put forward of the photographs and the statements to say that the wall was built after listing. Savills have made a statement saying it was built before listing, but is that statement just a statement or is it backed by evidence?
Chairman, could I, on a point of order, could I just raise the point that if we'd have been having this discussion 3 or 4 years ago or 5 years ago, then we would have relied upon the papers which are in front of members, which we have been reminded by officers on at least one occasion this evening is what we should be doing, and not bringing new evidence into a debate which now, because of technology, we're able to do. We have got the facts in front of us on which we are having our debate, and it is, in my view, not acceptable at this late stage to bring in new evidence. And I would like to also pick up on the point that Councillor Neil has made in my summing up, is that the B3347 is a very heavy vehicle usage road because of the New Forest lorry ban. And the New Forest lorry ban was the first thing which I encountered when I became chairman of the parish council in 1996 or thereabouts. So the volume of traffic and the size of the volume of traffic is totally different to what you see in fact. You know, you've got convoys, you have convoys of articulated lorries trying to negotiate the bend by the pub, and then the vehicles which are parked half on and half off the road, and other vehicles heading north, trying to squeeze through them before they get to them because they know they're going to get held up. So whilst it's very important, it's not very relevant in this particular issue. Chairman, I propose that we move to the vote. Thank you.
Mr. Chairman, as I was mentioned, can I respond?
There is a procedural motion on the table that takes precedence, but I would say from the chair and impartially that I have to draw members' attention to the note on page 19. For full details of all papers submitted with this application, please refer to the relevant public access pages on the council's website. So while I sympathise with the point, and we have had more information brought to us, but it is public domain, and I think it's fair to bring the point out, and I'm grateful to the legal advisor for making this point. It is there as something that is available and we are directed towards it, and therefore I have to say that I think that's not a fair point. The information is there. It is part of the application, although we would not normally refer to it. I have to say that's the point. There's a procedural motion that we move to the vote. Is that seconded? That is seconded. we'll take a vote on the procedural motion. All those in favour of the procedural motion that we move straight to the vote, please show. That's 4, 5 against. That is carried. We will now therefore take the vote. Councillor Jameson, you proposed, you have the right to sum up.
I've already summed up.
You've summed up. It is proposed and seconded, and here we are going to get into further details, but it's got to be done. We are about to, as I understand it, the feeling of the committee is that we wish to approve this application. We are going, if so, it will be contrary to the officer's recommendation, and I believe that we are required to provide grounds for the as to why we feel this application should be refused. So I wonder, is Councillor Jim should be approved? Sorry. So it's been a very long day, and this is my second planning meeting of the day. So, Councillor Jameson.
So whilst I may not have chapter and verse of the policies, it is in my view that it should be approved because it does, in fact, maintain the heritage status of the area, and the highway reasons it is a safer, what did I write down here? It is a safer access to the highway with the application having been approved than would have been had the application been refused. And I'm sure officers can find the relevant policies that support that.
Mr. Chairman, the seconder.
Yeah.
Can I say I think it does apply to BE14 and BE15, H1 and HE1 and HE2, plus our old H12 policy, because those things in there do cover all those aspects, Mr. Chairman.
Thank you, Peter. He's the chairman.
Chairman, there are 3 reasons for refusal in relation to the planning application. For summary purposes, you've got a conservation reason, reason 1. A second reason is a neighbour's amenity and living conditions reason, which I don't believe is addressed in the response that you've had from the Vice Chair, and you would need to provide a rationale for not.
Perhaps you could point me in the part of the report where it is.
Yes, Chairman. If you start from 8.11, impact on neighbouring amenity, and the concern is in relation to the proximity of the proposed parking space and the manoeuvring,
okay,
which will take place outside.
So my view with regards to that is that, in my view, as we discussed tonight already in the debate, is that it would not require a complex turning manoeuvre, whilst it may require a slight manoeuvre to get onto and off the front. So I don't believe that case exists.
Okay, are the officers, and I asked Mr. Hodges, are you happy with those reasons for approval? I know you're not happy with them, but do they meet the technical requirements?
Yes, as you said, Chairman, it's not my role to be happy either way. But no, you needed to provide a reasoning against each of the reasons for refusal. Yep. So thank you for that. What we would need to consider are any conditions that we may wish to attach to the grant of both the planning and the listed building consent.
At this point in the past, when we have come something like this, we've been known to ask the officers if there are any conditions that spring to mind.
Legally now, I'm afraid it's your responsibility to come up with some, and then we'll tell you whether they're right or not.
would it be appropriate to delegate conditions to be approved to the officers to be
So I think the answer to that's going to be no.
no. Okay.
But materials should be appropriate.
Chairman, the problem with that as a solution is we'd have to come back next month, in effect have your agreement to those conditions, so that won't deal with the matter now. So that's a principal issue.
So it can deal with the matter.
Yeah.
Well, ladies and gentlemen, sorry? You want it to adjourn for a few minutes?
Yeah. Yeah.
Sorry, Mike. Thank you.
If we adjourn,
yeah,
we can talk about the conditions and then come back in.
Yeah. We will adjourn for
2 minutes.
For a few minutes to discuss conditions. Right. We are. everybody back.
So, ladies and gentlemen, my proposal is 4 conditions. There should be a sample panel on site which shows materials, bonding and mortar mix. And that should be put on site within 3 months. And then a further 3 months for the completion of all the work. The wall retained on site thereafter, and appropriate surface water disposal scheme submitted and implemented.
Chairman, just one thing to add, to include the surfacing as part of the completion of the works, because you've got
yes,
indicated a change to the
hard,
existing
the
hard
ground,
surface,
yeah.
for that to be completed
Indeed.
as part of the condition.
You got that? Good. Thank you.
Thank you. It's proposed and seconded for approval, contrary to officers' recommendations for the reasons stated earlier, with the conditions attached. All those in favour, please show. 1, 2, 3, 4, 5. Against? Abstentions? That is approved. Thank you very much, ladies and gentlemen. Sorry? Oh, listed building consent. Can we take that is it is proposed and seconded that listed buildings consent be given. All those in favour, please show. Against? Abstention? Thank you very much. Ladies and gentlemen, thank you very much. That has been a very long and complicated meeting. Can I thank you all for your contributions? Can I just remind you that we will be meeting again before Christmas, in that there will be a briefing on the Bargate site, followed by a training. The pill will be sweetened by the provision of drinks and nibbles, by the chairman, according to long-standing tradition, certainly as long every year I've been chairman. And I look forward to seeing you all then. Thank you very much.
Meeting at 6 from 4 to 6.